a very good day I would like to wish to the respected lecturer, Dr. Ratna, and my fellow classmates here. We are here today, would like to present to our topic here is the Law of Treaties. So, here I am Mas Ishaliana Thomas, will explain the first case is about the Northern Sea continental shelf. First and foremost, I would like to explain the facts of the case. So basically, the case is about the delimitation of the Northern Sea that involved three countries, the Netherlands, Denmark, and Germany. The case was found difficulties on make an agreement to delimit the boundaries. So to settle this matter, the states officially used the equidistance method, whereas this would result in Germany an equitable outcome. So both nations, Netherlands and Denmark, they relied on the principle of equidistance, where the process of setting the borders in such a way that the borders in such a way that each location in the boundary is equidistant from the others, and it is also the method that we can use of calculating boundaries from the nearest points of the baselines in which state's territorial sea is measured. So in that case, Germany argued that the principle of equidistance was neither a mandatory rule in delimiting the boundaries nor a rule of customary international law. Secondly, I will explain the application of the treaties. So the case can be referred to the Article 6 of the Geneva Convention, which was used to decide the method of the delimitation for the states. So in that case, both nations, Netherlands and Denmark, they had already agreed to the Geneva Convention on the method of delimitation, but not Germany. Germany was one that did not ratify the agreement because they felt like even they felt like it's not even fair enough to divide the boundaries, even though they had to get the smaller space compared to the Netherlands and Denmark. Germany also argued that even the principle of equidistance will be used. Netherlands and Denmark, they claim that even if no action was taken to ratify the Geneva Convention Treaty, Germany was nevertheless obligated by it. So, as we can be referred to the Article 6 of the Geneva Convention, it stated that unless the parties had already agreed on a method for delimitation, or unless special circumstances exist, the equidistant method will apply. So Germany had already signed the treaty, but Germany had not ratified it. So this action was still bound by the Article 6 of the Geneva Convention.
Next, I will explain about the court decision. The court stated that the equidistance principle was not binding on Germany by way of treaty or customary international law. It means that the court decided that Germany had no unilaterally assumed obligations under the convention. The court also took notice of the fact that even if Germany ratified the treaty, they had the option of entering into reservation on Article 6, following which that particular article would no longer be applicable to Germany. It means that even if one were to assume that Germany had intended to become a party to the convention, it does not presuppose that it will have also undertaken those obligations contained in Article 6. Next, I will explain about the relationship with the principal law of treaties. State will be legally bound by treaty only when it has to ratify the treaty or has otherwise signified its consent to be bound, and signing the treaty does not usually amount to such consent. So ratification may depend on certain internal political and sometimes legal processes being observed, such as approval by a parliament. The precise requirements will of course vary from state to state. States which were not original signatories to the treaty indicate their consent to be legally bound by accession rather than ratification that state in Article 15. The Vienna Convention on the Law of Treaties 1969, which came into force in 1980, mentioned more specifically the treaty obligation on the third state, which refer to the states that are not the party of the convention. So in this treaty, it stipulated that obligations for the third state from the provision of the treaty only if it fulfilled the condition. First, the actual parties to the treaty intended the provision to create obligation for the third parties. And second, the third state expressly accept those obligations in writing, which stated in Article 35 of Vienna Convention, Law of Treaties. So what is stated on Article 34 to Article 38 of the Vienna Convention, Law of Treaties? In this article, it explains the rule and the right for the third state who are not a party of the particular treaty, but in certain circumstances, they are bound to obligate the treaty in a way that they must express their consent in writing, or it can be presumed in the case of the right given of the third states. So that's all from me. Thank you.
Next is our second case, which is case of dispute regarding navigational and related rights between Costa Rica and Nicaragua. Before we jump into this case, we will observe the locations of where this case take place. So this case involves two states, which is Costa Rica and Nicaragua, which are both Central American countries with coastline on the Caribbean Sea and Pacific Ocean to the west. So these both countries are separated by a river called San Juan River, which flowing along through the Caribbean Sea, and this river has been considered for a possible canal route between the Caribbean Sea and the Pacific Ocean since a long time ago. So this San Juan River has been the source of several boundary disputes between Nicaragua and Costa Rica regarding Costa Rica's use of this river. This case happened due to Costa Rica filed an application instituting proceeding against Nicaragua, Costa Rica concerning on the navigational and related rights on the sections of the Juan River that forms the boundary between these both states. According to the application made by Costa Rica, they affirm that Nicaragua has imposed a number of restrictions on the navigation of Costa Rica's boats and their passengers on that river. Meanwhile, Nicaragua argued that their navigation rights only extended to the vessel carrying commercial objects as opposed to the journey for the purpose of commerce. So the treaties that involve in determining the types of navigation between these two states is Treaty of Limits in 1958. So this treaty determined that the San Juan River belonged to Nicaragua, but Costa Rica was allowed to commercial access and obtain the right to free and perpetual navigation on that river. So the whole issues of misinterpreted of the treaty come arise due to the Article 4 of the 1985 treaty, which mentioned that Costa Rica will the perpetual rights of free navigation with trade objectives already with the Nicaragua or the interior of Costa Rica. So as we can see, there are the phrases of con objectos de comercio. This phrase has become the issues when the both states misinterpret it, and this requires the international courts of justice to justify and solve this case.
My name is Nadrana binti Imran, metric number 278650, and today I will explain about the application of the treaties on the navigational and the related right of the Costa Rica and Nicaragua. Based on the Article 6 of the 1858 Treaty, established an exemption granting of the Costa Rica perpetual right of free navigation in the lower course of the San Juan River for the specific use. The precise limit of this exemption, as well as the constraint it imposed on the Nicaragua's exercise of the sovereignty that were used in this case. The parties did not agree on where their boundary should be, and it should be emphasized that the navigational provision of the 1858 Treaty and the decision in this case do not apply on the upper coast or the non-boundary portion of the San Juan River, both of the whose bank in the Nicaraguan territory, while explicitly acknowledging the Nicaraguan sovereignty over the San Juan River on the Article 6 of the 1858 Treaty also curtailed the authority by granting the Costa Rican boat conditional navigational right. Next is the court decision. The court is not convinced by the Nicaragua agreement in which Costa Rica right of the free navigation should be interpreted narrowly because of it represents the sovereignty over the river conferred by the Treaty on the Nicaraguans. It is appropriate to consider that the issue of the meaning of the phrase of the con objectus de, as it used in the Article 6 on the 1858 Treaty, specifically whether it means for the whole purpose of the Costa Rica content or with the article of the Nicaraguan content. The court, however, on the view that interpretation advocated by the Nicaraguans cannot be upheld. The meaning of the interpretation of the phrases will make even less sense as compared to the interpretation made by the Costa Rica. The court concluded that the term used to define the scope of the Costa Rica right of free navigation, particularly in terms of the commercio, must be considered to have meaning they have on the occasion when the treaty is to apply and not necessarily their original meaning.
So next, we will be discussed on the relationship of this case to the principles of law of treaties. So as we know, the principles of treaty interpretation has been highlighted in the Part 3 of Vienna Convention on the Law of Treaties. There are 3 articles that mention on the interpretations. The Article 31, which about the general rule of interpretation. Article 32 mentions about the supplementary means of interpretations. Article 33 mentions about the interpretations of treaty authenticated in the 2 or more language. So in this case, it highlighted that it may be necessary to have regards to the usage of terms in contemporary times, especially to the older treaties. In short, we can say that when the meaning of a phrases has changed, since the treaty was signed, it shall not be taken into account when the treaty is being interpreted for application reason. As we can see, the Article 33(4) in Vienna Conventions of the Law of Treaty mentioned that except where the particular text prevail in accordance with the paragraph 1, when the comparisons of the authentic text disclose a different meaning which the applications of the Article 31 and 32 does not remove, the meaning which best reconciles the text have regards to the objects and the purpose of the treaty shall be adopted. So from this case, we can extract that the Costa Rica and Nicaragua case demonstrate that the ICJ will adhere to the primacy of the text in the treaty interpretation in order to identify the parties' intentions. On the other hand, we can extract from this case is about the importance of the treaty background as well as the possibility of relying on broad principles of international law when they're interpreting a treaty. So since this case is about the mutual agreement between the both states, the future behavior of these both parties, Costa Rica and Nicaragua, as defined by the Article 3B of the Vienna Conventions, may result in a change from the future original intent. This case also demonstrates that the treaty text does not remain static over time, and that when interpreting a treaty, it may be necessary to consider the usage of the terms rather than the intentions of the treaty drafters during they made the treaties. And this approach gives international courts a significant role in interpreting the old treaties. So we can see that in conclusion, the more parties sign a treaty, the more difficult it can be applied the principle of interpretation to, as being set up in the Article 31 and 32 on Vienna Conventions of the Law of Treaties.